Just as species evolve in response to new environmental challenges and opportunities, law evolves in response to the effects of its own pronouncements on human behavior. This video examines one microcosm that illustrates this sort of evolution in Delaware corporate law. The environment in question is the situation where a controlling stockholder acquires the shares of minority stockholders by means of a merger, a transaction known variously as a freeze-out, a squeeze-out, a going private merger, or a cash-out merger. Because the controlling stockholder is the buyer and also holds the controlling vote on the merger, it stands on both sides of the transaction and stands to benefit at the expense of the minority stockholders. In this situation, and citing case law going back decades, the Delaware Supreme Court's landmark 1983 opinion in Weinberger v. UOP made it clear that where one stands on both sides of a transaction, he has the burden of establishing its entire fairness, sufficient to pass the test of careful scrutiny by the courts. Discussing this entire fairness standard, former Delaware Supreme Court Justice Jack Jacobs recognized that the UOP case helped to clarify what was otherwise a murky concept.
There was case law all the way back to the 50s that dealt with what we call the entire fairness doctrine. But it was a doctrine that never had any real definition. That is, there weren't too many. There were not any guidelines, that established that gave more precise instructions as to what the court should do. And so, one of the concerns we now know of the Supreme Court, and I'm sure it was fueled by the law review articles, was that entire fairness is like the chance of his foot. It all depends on, who the judge is and what time he got up in the morning, what he had for breakfast and all that. So one of the contributions that was made by Weinberger was to try to put more content into the application of the entire fairness standard of review, which is what it is. So that was the background.
An important, even revolutionary part of that content was a passing observation in footnote 7 of the UOP opinion. The court suggested there that the Freezeout merger at issue might have been sustained if a special committee of independent directors had negotiated the terms of the merger on behalf of the minority stockholders. In the same footnote, the court cited cases, including the 1971 Chancery opinion in Puma v. Marriott, ruling that as long as a transaction with a controlling stockholder is negotiated by disinterested, independent directors, the very deferential business judgment rule standard of judicial review applies. Justice Jacobs singled out footnote 7 in describing the UOP case, but he was skeptical about what it really meant.
The footnote in Weinberger, and really, what I consider to be the animating force behind Weinberger, which is that if you can replicate a real market transaction involving third parties negotiating at arm's length, then it should fall under business judgment review, because that's what happens when you have two completely disconnected companies that are negotiating a merger or consolidation. But Weinberger didn't really say that. It suggested it, but it didn't say it, and that was an unanswered question.
Despite that uncertainty, however, UOP powerfully incentivized Freezeout deal advisors to recommend that controlling stockholders negotiate the deal terms with a committee of independent directors. Delaware M&A lawyer Gil Sparks of Morris, Nichols, Arsht and Tunnell explains this effect of UOP.
What it left behind was an entirely new regime in terms of parent-subsidiary mergers and cash-out mergers, which survives to this day. I mean, it is nobody after this opinion would really do a cash-out merger without having a special committee of outside directors negotiate.
Nevertheless, it remained unclear whether use of a special committee would still leave a court to examine the fairness of a cash-out merger, based on extensive discovery and a trial, or would result in application of the business judgment rule and the elimination of litigation on a motion to dismiss, cutting off discovery and trial. The choice was important, as Tom Allingham of Skadden, Arps, Slate, Marr, and Flom explained.
Well, first of all, under the entire fairness review, it's the burden of the defendant to prove the entire fairness of the transaction. That meant effectively that motion practice was useless. So if the transaction was not enjoined, the buyer was in a position in which if entire fairness review applied, and if you were a controller, entire fairness did apply. There was no question about that. So the question became, what situation do you find yourself in post-injunction? And the answer was, you find yourself in a position where your risk is very high and there is no certainty. And so there's no motion practice, there's no legal issue on which cases can turn. And so plaintiffs, generally speaking, had a tremendous amount of leverage, which was gave rise to the inefficiencies. You sort of have a choice of, you can contemplate the notion of a trial with the possibility that if you lose the trial, you don't know what the damages are, and so it could be a very large damage award. Or you can say, all right, I'm gonna examine cost benefit and settle. And plaintiffs understood that that was a powerful piece of leverage that they had.
Freezeout planners also considered another possible way to avoid litigation over the fairness of the deal, namely requiring that a majority of the minority stockholders vote to approve the deal. Again, here there was Delaware case law from 1952 and even earlier, suggesting that such stockholder approval would spare a freezeout from judicial scrutiny of fairness. And in 1985, soon after UOP was decided, the Delaware Supreme Court ruled in Rosenblatt versus Getty Oil that approval of a merger, as here by an informed vote of a majority of the minority shareholders, while not a legal prerequisite, shifts the burden of proving the unfairness of the merger entirely to the plaintiffs. As with the Special Committee of Directors, however, it remained unclear whether use of a majority of minority stockholder vote would still leave a court to examine the fairness of a cash-out merger based on extensive discovery and a trial, or would result in application of the business judgment rule and the elimination of litigation on a motion to dismiss. And that's where our evolutionary story picks up again, with a tale of two conflicting opinions from the Delaware Court of Chancery. One of those cases was Citron versus Dupont in 1989. Justice Jacobs, the author of that opinion when he was a vice chancellor, explains the background to Penn Carey Law School's Larry Hammermesh.
The case that you're talking about actually involved one of the cleanest deals that had ever come before the Delaware courts. It was Dupont deciding for purely business reasons that it wanted to acquire the remaining 30% of Remington Arms, the gun company that it had owned since time immemorial, maybe since the Civil War for all. And at that time, because it was a gunpowder company, it made sense to have a gun company. But you know, over during most of the at least during the last 50 years of the 20th century, it did not play a major role.
Better living through armaments just doesn't roll off the tongue as a corporate slogan.
No, because it was a specialty chemicals company, not a gunpowder company. So they decided that owning 70%, they had the votes to do a cash-out merger. They decided not to do a cash-out merger, that they were going to do a stock-for-stock merger so that all the shareholders of the 30% public shareholders of the gun company would become shareholders of Dupont. So what's remarkable about the case, I mean, is that Weinberger was not decided until after this transaction took place. And yet you would believe that the lawyers for the company, which happened to be Covington and Burling, were clairvoyant, because everything they advised the company, Dupont, to do is precisely what the Supreme Court said should be done basically to pass the entire fairness standard, even as elaborated in that case.
That's the footnote in UOP that talks about achieving benefits of more deferential review through use of a special committee of directors.
So, number one, Covington advised the Dupont to set up a special committee of non-Dupont directors. So all the Dupont directors recuse themselves from any involvement at all in negotiating or approving the transaction. Well, negotiating the transaction. I believe, also recommended that that there be a majority of the minority shareholder vote, so that Dupont, unless a majority of the, unless a majority of the 70% agreed.
30% or whatever.
The 30%,
right.
They would have a veto power, and Dupont would not do the transaction. That was accepted.
That left Vice Chancellor Jacobs with a difficult legal question to resolve, as well as an awkward situation involving his colleague, Chancellor William Allen. In his 1988 opinion in the TWA case just a year earlier, Chancellor Allen concluded that both the device of the Special Negotiating Committee of Disinterested Directors and the device of a merger provision requiring approval by a majority of disinterested shareholders, when properly employed, have the judicial effect of making the substantive law aspect of the business judgment rule applicable.
So one of the major issues that I had to decide was, is this a business judgment case? In which case, it would be an easy opinion to write. Or would it be an entire fairness case, in which circumstance there would be a much more textured kind of analysis and having to grapple, with Weinberger, because there had never been a fully developed post-trial case where the Weinberger apparatus had to be applied. My inclination was to apply business judgment, to hold that it was business judgment. There was a decision by my then colleague, Bill Allen, Chancellor Allen, in the TWA case in which he had done exactly that. But unfortunately, one of my hotshot law clerks discovered a 1985 Delaware Supreme Court case called Rosenblatt versus Getty Oil, which involved, although different, a different kind of transaction, the same paradigm facts, the same master facts. And in that case, the Supreme Court said no, it didn't really, it just said, and I don't even know to what extent it was litigated, that the standard of review, even though this was the cleanest deal that they had, would still be entire fairness, but the burden of proving unfairness would shift to the plaintiff. In classic entire fairness, the directors, the controller, always had the burden of proof. So that was a change.
Faced with the arguable inconsistency between Chancellor Allen's business judgment rule holding in TWA on one hand and the Delaware Supreme Court statement in Rosenblatt on the other, Vice Chancellor Jacobs had a heart-to-heart with his colleague Chancellor Allen.
So there was nothing in the TWA opinion that addressed that precedent. It wasn't cited, and nothing in the Rosenblatt opinion that explained why business judgment wouldn't be the standard. So, what did I do? I went into my colleague's office and said, Bill, I got a problem. and told him about Rosenblatt, and he said, and I said, look, I find that I'm in the position where I may have to go in a direction completely opposite from where you went, and it would be very public. And he said, well, if you have to, you have to, because nobody cited Rosenblatt to me. And when I decided TWA, I said, okay, I'm relieved to hear that. Now, here's my other problem. Rosenblatt doesn't really give any rationale for why, it would be, why there would continue to be entire fairness review rather than just shifting standards to business judgment. And they didn't. And so, because I was now going to have to apply this, and I didn't want to do it just by saying, well, the Supreme Court said,
They said so.
Said so, and so that's it. To try to come up with some rationale that would make sense. And so literally, Bill Allen and I in his office forged a rationale, which was that even if you have all of the safeguards in place, that is the procedural safeguards, that the shareholders would, there's a risk that the shareholders would approve the deal out of concern that if they didn't, then the controller, frustrated over having its deal voted down, would take some kind of retaliatory step later on, such as cutting dividends, trying to delist or whatever. And that became the rationale.
This inherent coercion rationale that the two chancellors concocted didn't persuade many corporate lawyers.
That was not a rationale that was warmly accepted on Wall Street or by the corporate community. I recall after writing the opinion in Citron, where I upheld the deal, but based on the modified entire fairness paradigm, that one major Wall Street firm said this is the stupidest thing that they had ever heard of, and that the rules should be that what happened at TWA, and they had a point. I thought they were right, but I was bound by Supreme Court precedent.
But whatever uncertainty about the state of the law existed before 1994, the Delaware Supreme Court eliminated it that year in Conn versus Lynch Communications. That case affirmed that even when an interested cash-out merger transaction receives the informed approval of a majority of minority stockholders or an independent committee of disinterested directors, an entire fairness analysis is the only proper standard of judicial review.
The bottom line was that in 1994, the Delaware Supreme Court clarified, we still had TWA and Citron as polar opposite cases, and they resolved that opposition in favor of Citron. To my dismay, I was hoping they wouldn't. But then
quoting you at great length.
Yeah, unfortunately, yeah. Well, what Bill and I had come up with.
Right.
Great.
So where did that leave things? In an ordinary freeze-out merger, there would have to be a trial to determine fairness, even after approval by a special committee of disinterested directors or by a majority of the minority stockholders. But legal evolution didn't stop there. In 2001, in Glassman versus Unocal Exploration, the Delaware Supreme Court noted that if a controller owns more than 90% of the corporation's voting stock, Section 253 of the Delaware General Corporation Law enables it to acquire the remaining shares by merger without needing approval from the corporation's board of directors or a vote of its stockholders. Hence the term short-form merger. The Supreme Court concluded that in order to serve its purpose, Section 253 must be construed to obviate the requirement to establish entire fairness in a short-form merger. Deal planners adapted creatively and quickly to this legal development. Controlling stockholders who didn't own over 90% could simply make a tender offer to acquire enough shares to cross that 90% threshold. Then, do a freeze-out short-form merger. After Unocal Exploration, they wouldn't have to prove that the merger was entirely fair. In fact, Fairness wouldn't be an issue at all. But what about the controller's offer to buy stock to get over the 90% threshold? Would the courts step in to evaluate the entire fairness of that offer? That was the issue that the Court of Chancery addressed in 2001 in the Siliconix case. Kevin Abrams, the lawyer for the plaintiff in that case, explained the competing arguments.
We teed up in Siliconix an argument to the Vice Chancellor that the so-called tender offer cases were inconsistent with the primacy of directors, the responsibility of directors, and the burden of proof rules that have been developed in prior cases. In Unical, for example, in the 1980s, the importance of affirmative responses by the board and the power of the board to deal with an unsolicited bid were emphasized. In McMullen, we have very specific authority on the affirmative duty of directors to push back to secure the best available deal. In Conn versus Lynch, we have rules for entire fairness applicable to a controlling stockholder long-form transaction that dealt with a coercion recognition by the Delaware courts that clearly existed in the tender offer context, and therefore we thought should have extended an entire fairness test to a controller go private tender offer. We had decisions in, for example, Unical Exploration, which presented a different perspective. In the Unical Exploration recognized that controllers are not subject to entire fairness in conjunction with a short form merger. And then we had Cox Communications, which is one of several, I think a minority of cases, recognizing that tender offers were voluntary transaction and there was no duty to pay a fair price. So notwithstanding the Unical Conn versus Lynch recognition of the importance of directors pushing back on unsolicited offers and the duties of entire fairness in controlling stockholder transactions, there was a different body of Delaware law which was cobbled together by proponents of squeeze-out tender offers to argue that there was no duty of entire fairness, no duty to pay a fair price, and very limited procedural protections need to be included in the transaction.
Despite that body of law, plaintiff's counsel Mr. Abrams thought at the time that he had a pretty good case.
Okay. All right, so just sort of by way of background, Vichy was a manufacturer with semiconductor components, things of that nature?
Yes.
And it owned, a little over 80% of Siliconix?
Yes.
Siliconix was NASDAQ traded?
Yes.
Okay. All right. Now the stock price, as I recall, and I'm just trying to bring back what the court said in the opinion, but the stock price had been considerably higher at one point up in the 160s, and it had dropped considerably to under 17 at the time of the proposal, the cash tender offer proposal. Is that basically right?
That's basically right. We thought that Vichy, the controlling stockholder, was acting in a particularly opportunistic fashion to try and pick off the minority shares at a down cycle in the Siliconix economic experience, and we had significant valuation arguments to suggest that the price was worth considerably more than the implied value by the exchange offer. In addition, the deal was noteworthy because, unlike the deals that all of us have litigated, it involved a controlling stockholder marking to market its stock against the Siliconix stock, so that there was not only no fundamental analysis on the valuation issues related to Siliconix or to Vichy, which you would have expected in a stock-for-stock deal, but there was also no premium offered to the minority stockholders in conjunction with the buyout transaction, which is extraordinarily unusual and we hoped would get the attention of the Vice Chancellor.
Mr. Abrams also attacked the process that Vichy followed in structuring the deal.
Now, special committee then proceeded to meet with respect to that modified offer, is that right? And what happened then?
The special committee, in our view, never negotiated with the controller to increase the exchange ratio, never asked for an increased price, and ultimately determined to take no position on the offer. All of this coming against a backdrop of what we construed as Lehman Brothers, the financial advisor, telling the special committee that $34 was the bottom end of their fair value range. That was hotly contested by the parties, but in the the code that all of us are used to dealing with investment bankers on, it was pretty clear that Lehman was not impressed with the implied value in the exchange offer. The special committee knew that and nevertheless decided to take no position. So we argued that the special committee had abdicated its responsibility under the McMullen Doctrine to affirmatively represent the public stockholders. It's highly unusual for a special committee to decline to ask for more. It's highly unusual for a special committee to decline to negotiate. But we ultimately realized that, from our perspective, effectively the fix was in from the beginning. Two people with very close ties to the controlling stockholder were on the special committee, and it ultimately was not surprising to us. They declined to take a position and declined to negotiate. We thought all of these facts put together should have sent off the alarm bells in the Vice Chancellor's mind and led him to be much more focused on the substantive and procedural and economic unfairness of what was going on. And we thought there was both inherent coercion and structural coercion under the Kahn versus Lynch doctrine as a result of the sheer presence of a controlling stockholder attempting to jam the minority with a tender offer in a short period of time. There was structural coercion by virtue of the failure of the controller to commit to a second step merger on the same terms. There was also a threat of delisting. That was hotly contested, and we thought that if you put all of these factors together, the court should have found, either as a result of disclosure violations or as a result of process violations, as a result of the controller's inability to show a fair price, and because of the coercion that we thought was existing in the offer, that some or all of those factors would have gotten us over the hurdle on the probability of success prong for an injunction application.
But they didn't.
So based upon what the court did, and I think it's accurate to say that but correct me if I'm wrong, that there was no duty to offer a specific fair price unless there was actual coercion or disclosure violations. Is that essentially
that was the holding of the court?
Position that the court took?
Yes, and that was the application by the court of the Unical exploration decision, and the court was relying on existing doctrines for the what I'll call the pro-tender offer rules.
The tension between the ruling in Siliconix and the doctrine established in Kahn versus Lynch was palpable.
The fundamental problem with the Siliconix line of cases is that they effectively held that if a controller makes a tender offer subject to a majority of the minority tender condition, the business judgment rule applies as long as there's no coercion or disclosure violation. We thought at the time, and Vice Chancellor Strine must have been thinking about this, that that is fundamentally inconsistent with Kahn versus Lynch. In Kahn, even if you had special committee approval, or if you had disinterested stockholder approval, you still had an entire fairness claim that could not be dismissed, and if you represented the minority stockholders, would get a chance to test the process and the fairness of the price through a non-dismissible case. So at the end of Siliconix, we essentially had a motion to dismiss opinion written against us by applying one strand of Delaware law when a functionally equivalent and economically equivalent long-form merger subject to Kahn versus Lynch would have given us a shot at proving entire fairness.
And plaintiff's counsel felt that there was a lot more coercion in Viché's tender offer for the minority shares than the inherent coercion in the rationale developed in Citron and approved in Kahn versus Lynch.
Well, we had three coercion arguments recall here. One was the timing of the offer. The second related to the what we thought was the refusal of the controller to commit to doing a second step merger if it got to 90% on the same terms and conditions. And there was also, in our view, a threat actionable under the Chicago-Milwaukee doctrine of delisting the stock after the completion of the exchange offer in the event they did not complete the merger. So any one of those three theories constituted what the courts referred to as structural coercion, and the court did not buy those arguments, and it also did not deal adequately, from our perspective, with the inherent coercion argument that's been referred to in Delaware law now for decades as the 800-pound gorilla problem associated with a controller making any type of a proposal that would affect the minority's economic interests. So we thought there were plenty of coercion arguments that the court could have grasped onto, but instead the court went with a different doctrine of Delaware law that was, fortunately, I think, from the perspective of all of us in terms of doctrinal development, was on its way out.
Indeed. Just a year after Siliconix was decided, the Delaware courts started to reduce the disparity between the regular merger route and the two-step tender offer and short-form merger route to a freezeout. In his 2002 opinion in the Pure Resources case, then Vice Chancellor Strine ruled that our law should consider an acquisition tender offer by a controlling stockholder non-coercive only when 1. It is subject to a non-waivable majority of the minority tender condition. 2. The controlling stockholder promises to consummate a prompt Section 253 merger at the same price if it obtains more than 90% of the shares. And 3. The controlling stockholder has made no retributive threats. This ruling came a year too late to help the plaintiff in Siliconix, but counsel for plaintiff in that case nevertheless considered it a welcome development.
Then Vice Chancellor Strine took on directly the forms of coercion that are inherent in a long-form merger as well as a controller tender offer, found that if you buy the coercion argument, you can't have different legal regimes, entire fairness versus business judgment rule applicable, and the court took the first probing soft step to refining the Conn versus Lynch doctrine to impose a different liability and a different standard of judicial review depending upon the procedural protections employed by the controller and the representatives of the minority in the squeeze-out transaction.
After Pure Resources, tender offers by controlling stockholders faded away, as Stephen Jenkins of Ashby and Geddes explains.
As doctrine, Siliconix was a dead end. And it was a dead end because while part of it, the tender offer argument, I believe, is logical, but it didn't really work. And you put too much on the disclosures, there's the disclosures become important, other structural coercion. It didn't work very well. And so it disappeared. These tender offers by controllers disappeared over the next several years as people were trying to find new ways to do transactions that wouldn't result in a lot of litigation. Because what we had after the tender offers disappeared is there was no way to do a controller transaction without getting into entire fairness litigation.
So what took the place of tender offers by controlling stockholders was what came to be described as the kabuki dance of shareholder class actions purporting to challenge freeze-out mergers. How did this dance work? Steve Jenkins and Kevin Abrams, both involved in the contested settlement of the 2005 Cox Communications case, explain.
My memory is the settlement hearing was also the fee hearing, and everything was together. We came in to object to the fees. I had as my co-counsel Professor Elliott Weiss of Arizona, who had written a paper about litigation in Delaware on these kind of cases. And what his paper showed is that the series of plaintiffs' firms were routinely settling these cases for a big fee and not much else, and that it was not an appropriate use of judicial resources, not an appropriate way to settle cases. So we didn't object to the settlement because we didn't see that there was anything wrong here. They did this deal the right way. We didn't see that there was any purpose for paying attorney's fees in this case. This was not an unfair deal to the stockholders. But what we came in and say, hold it. Delaware's gotten out of line on the issue of paying large fees or awarding large fees to plaintiffs in cases in which they're challenging usually a controller deal. And there's no way for somebody like Kevin representing the defendant to stop the litigation unless he gets a release as part of a settlement early on. And so defense lawyers were routinely settling these cases because they were dealing with the Delaware law at the time that said, if you don't settle early, you're going to spend years in litigation. So better have some small settlement and large attorney's fees than spending years in litigation, and for something that's fundamentally fair.
The problem facing the controlling stockholder in this context was the inability to secure the immediate dismissal of the case. So no matter how good a job the special committee did, no matter how high a price we paid, no matter how good the disclosures were, the plaintiff's lawyers had potentially an opportunity to litigate the case through at least summary judgment with all of the attendant discovery cost and eye off the problem for management, as well as immense litigation fees for a special committee, the bankers, and the controlling stockholder. So by that time, there was an accepted procedure with a group of plaintiffs' lawyers who were understandably risk averse against trying to take on a deal that had been fully vetted and negotiated by a special committee, such that we would negotiate ostensibly with the plaintiffs' lawyers. At the same time, we were negotiating with the special committee and attempt to get everybody to the same place at the same time. The Vice Chancellor recognized that there was a win-win situation for everybody. Plaintiffs' lawyers were getting rich for taking no risk and doing nothing. Controllers, in the context of a multi-billion-dollar deal like Cox Communications, were paying a relative pittance to the plaintiffs' lawyers to go away and save themselves a lot of money. And I was able to avoid a quasi-appraisal case on entire fairness grounds for my client by throwing some money at the plaintiffs' lawyers.
Kevin Abrams explains how this accepted procedure, the kabuki dance, played out in the Cox case itself.
Okay, Kevin, let's go back if we could and just paint the picture of what the deal was here. I take it that the Cox family made a proposal to buy, all of the public shares it didn't own? And if that's correct, or if it isn't, straighten it out, but kind of paint the picture, if you would, for what the deal was and how it evolved.
Cox Enterprises proposed a premium-priced long-form merger to Cox Communications to squeeze out the public shares. Cox Communications had two independent directors with no affiliation whatsoever with Cox Enterprises. Those two were appointed as a special committee. We gave a standard set of special committee resolutions to the special committee, giving the special committee plenary powers, and that was accepted by the special committee and its counsel. We then proceeded to engage in a series of negotiations. Jim Kennedy, the head of Cox Enterprises and a internationally respected business leader, met with the chairwoman of the special committee, and they had it out over the price, and she was correctly convinced that Cox Enterprises was going to drop the deal unless they accepted the enhanced price that Cox Enterprises was prepared to pay. At the same time, my job as litigation counsel to Cox Enterprises was to deal with the, as I recall, 13 lawsuits that were filed and consolidated in Delaware, and the 5 lawsuits filed and consolidated in Georgia. All of the national plaintiffs' firms were involved. The plaintiffs eventually got themselves organized, and Arthur Abbey, well known to all of us, was the top dog among the plaintiffs' lawyers. And it was my job to engage in what is now referred to as the kabuki dance, to attempt to get the plaintiffs to agree to a final price and a transaction structure which would be consistent with where we ended up with the special committee. There were 2 independent paths of negotiation. Both involved arm's length conversations. Frankly, the court is correct in pointing to be charitable cumulative or supportive efforts by plaintiffs' counsel, but there was by that point a well-known path that we would go down to involve plaintiffs' counsel in the discussions and over the price and the deliberations by the controller on what the price and the terms should be. We deliberately left out of the front end of the proposal a majority of the minority voting condition. We knew from pure resources and from our experience in the prior years that that was going to be something demanded by the special committee, and we expected to trade that off to try and save some money, to be blunt about it. At the end of the day, the plaintiffs' lawyers made a presentation with their views on financial fairness and demanded a majority of the minority voting condition. The special committee was proceeding on an independent track, and as was customary at the time, the trains ended up in the middle, and I was able to get the plaintiff lawyers to agree to a settlement which matched the terms that we were prepared to agree to with the special committee.
Once the parties in Cox agreed to a settlement, the remaining matter was the application of plaintiff's counsel for a fee award. And Mr. Abrams, counsel for the defendants, and Mr. Jenkins, counsel for the stockholder objecting to the fee award, took a dim view of what plaintiff's counsel had contributed.
You announced a proposed deal that was fully negotiable. And when did the plaintiffs come in?
4 o'clock in the morning on the date of the announcement.
Okay. Well before any deal was actually agreed to. Is that correct?
No, we made a proposal just after midnight. The first complaint was filed at 4 a.m. East Coast time, and the rest of them piled on.
If you think about the first suit, as Kevin says, as there was an announcement at midnight, was it? 4 hours later, 4 a.m. in the morning, the first lawsuit was filed. Now, how much thought can be given to that suit? And if you went and looked at it, you would see it just took a standard form and took the details of the press release and said it was unfair. How can anybody possibly have looked at that, weighed it, and decided and come up with the conclusion this is an unfair transaction, this is a violation of fiduciary duty, especially when it said this is just a proposal going to the special committee. I think that fact.
Right. It was negotiable, fully negotiable.
Yeah, I think the fact that they started filing at 4 in the morning, 4 hours after it was announced, based on nothing.
I mean, that's not all the court said. It went on to say that there were no real novel legal arguments. It was a standby. No, there was a special committee that was focusing on this. There was no appreciable risk. It was a very low risk case. A variety of points to that effect.
Yeah, it didn't deserve, like a lot of these, it didn't deserve any significant legal fee.
Nevertheless, the court awarded plaintiff's counsel a fee that most of us would consider pretty significant, over $1 million. But it was a lot less than what they had asked for. Here's how the court arrived at that result.
The first thing is, what's the benefit to the corporation? And we said, in reality, nothing. The corporation had to go through a kabuki dance, but it didn't get any more money than the special committee because the special committee worked the right way and it got the maximum dollars. And then we went through and we said, it's really zero, and I think we put that in our brief. Now, we also understood that under Delaware law, that the fact that they had filed suit early enough and that the price increased thereafter, they would be deemed, unless there was strong proof to the contrary, they would be deemed to deserve some credit for the price bump. No, I thought then, and I think now, that in that particular case, there was not a penny added by their actions. But nevertheless, because of that presumption, and Vice Chancellor Strine in the end gave them about $1 million?
$1.25
million instead of the original 4 or 5 or 6 million that they asked for.
A little more than 4, as I recall. So
Yeah.
it was a significant drop.
It was a significant cut.
And that cut in the fee award had a predictable effect.
Yeah, I mean, in the end, the fee didn't make the plan, because how many different suits were there again in Delaware?
13 in Delaware, as I recall, and 5 in Georgia. And there were separate fee applications paid in both jurisdictions.
But can you imagine the 13 law firms arguing about 1.4 million?
I don't want to do that. Okay. So
They were not happy with that result, and thereafter it caused a diminution of the number of lawsuits coming in on these cases.
a positive event, I guess, from some people's perspective, which is understandable. Okay. So
In part, the diminution of plaintiffs' cases attacking controlling stockholder transaction was caused by the realignment of plaintiffs' lawyers' incentives. They understood as a result of the drop from just under $5 million in the fee application to a fee award of just under $2 million that they weren't going to make the kind of money they needed to buy their houses out in the Hamptons.
Despite this effect of making unproductive litigation marginally less attractive to plaintiffs' lawyers, the underlying legal problem remained. How could a controlling stockholder avoid the extensive litigation required by application of the entire fairness standard? Dictum in Cox hinted at a solution, one that would end up having even more impact than the cut in attorney's fees. In his opinion, Vice Chancellor Strine advocated for a reform of Delaware law, in which the courts would invoke the business judgment rule standard of review when a going private merger with a controlling stockholder was effected using a process that mirrored both elements of an arm's-length merger. 1. Approval by disinterested directors, and 2. Approval by disinterested stockholders.
The more important driver of the refocusing of litigation efforts came as a result of the announcement of the new procedural rules of the road for controlling stockholder transactions, and the amplification, elaboration, and specification of the procedural rules regarding special committees, no coercion, full disclosure, majority of the minority tender conditions. All of those were clearly understood years after the Pure Resources opinion as establishing a framework for transaction planners to put together deals that would give people in my position the ability to tell the plaintiffs' lawyers of the world that, we did this according to the rules, and this is not a fruitful area for you guys to litigate. And as we've discussed earlier today, the plaintiffs' lawyers reacted to that by really starting to focus more critically on transactions that deserved attack, as opposed to going through the road exercise of filing 13 complaints in the space of a few days and getting bought off at the time of the special committee approval.
Kevin, is that the real takeaway from that?
Yeah, the empirical evidence is clear that following the Cox Communications decision, controlling stockholder go private transactions were structured as two-step mergers. The prevalence of special committee approval requirements and majority of the minority requirements exploded. The number of these lawsuits dropped considerably. The lawsuits that were brought focused on director conflicts, banker conflicts, controlling stockholder overreaching, tipping, the sorts of things that are obviously subject to challenge in any merger context, but did not rely upon the false premise of Kahn that there's always coercion and therefore entire fairness applied to everything.
But in spite of encouragement from the Cox opinion, the promise of business judgment rule review of a freezeout remained untested for a long time.
There had been rumblings in the Delaware corporate bar and also the Delaware judiciary for a long time that the process of reviewing controller transactions was, depending on who you talk to, ranging from inefficient to broken. And there'd been a fair amount of talk about how that might be improved. But because of the structure of controller transactions and the way they were being reviewed, it was very hard for a controller to try to bring a case that would tee up the issue of whether you could get business judgment review for a controller transaction if you were willing to structure the transaction with certain procedural protections. It was very hard for controllers to see the benefit of that. So from a doctrinal point of view, the issue remained, but nobody was willing to tee it up.
Nobody, that is, until Ron Perlman, the controlling stockholder of McAndrews and Forbes worldwide, or MFW, took the risk. Skadden partner Tom Allingham explains.
I had the luxury for 30 years or so of having represented McAndrews and Forbes and its owner, Ronald Perlman, in a whole variety of corporate transactions in Delaware. And I knew, because the structure of McAndrews and Forbes as a holding company involved lots of controlled corporations, that this was an issue that was of real interest to McAndrews and Forbes and Ronald Perlman and his in-house legal team. And so when I got a call from one of my corporate partners that McAndrews and Forbes was considering a control transaction involving McAndrews and Forbes worldwide, which was the controlled corporation in this transaction. We started thinking about whether this could be a transaction in which we might consider the possibility of implementing the dual procedural protections, shareholder vote on the one hand, and a special committee empowered to review the transaction, to see whether we could get business judgment review. And it was interesting from that perspective because it was both had the potential to be useful for the McAndrews and Forbes worldwide transaction, but from the point of view of McAndrews and Forbes itself, there was a likelihood, or at least a possibility, that this would be doctrinally useful for my client in other transactions as well. So Perlman, I think, if not uniquely, unusually among people who might consider this structure, was willing to think about this, I think, more seriously than most potential clients.
So what did you expect the major legal issues to be if you structured the transaction with these dual protections?
There was an obvious major legal issue, which was that there were Delaware cases from the Supreme Court that could easily be read, and plaintiffs had frequently read, to say, you do not get business judgment review of controller transactions, period, end of story. I personally did not believe that that's what those cases meant. I didn't think it was consistent with the long arc of Delaware corporate law. And I thought we could prove, I didn't think that, I was confident, in fact, judges on the Chancery Court had already basically said, we don't think that's what those cases mean, but it's for the Supreme Court to say. So I was confident that we could get past that issue in the Chancery Court, and I felt pretty good about, we evaluated who was sitting on the Supreme Court at the time, and honestly, right down to the justice, thinking about what was their connection to those cases, the Conn v. Lynch case, for example. And we felt pretty good about that particular issue. So if we could get past the stare decisis problem, then I thought the issues were the straightforward ones. If the controller is willing to give up all of his power, shouldn't he also then be entitled to a standard of review that is not the controller's standard of review? So that was the legal issue. The factual questions were then, could we persuade the vice chancellor or chancellor, whoever we got, and ultimately the Supreme Court, because we were sure it would be appealed. Could we persuade them that in fact the controller had relinquished the power of control so that he should be entitled to a standard of review that didn't reflect control?
With those questions in mind, counsel for McAndrews and Forbes did everything they could to err on the side of caution and set up as clean a test case as possible.
Let's talk a little bit about the transaction that actually occurred that became the subject of the litigation. What were sort of the dynamics of that transaction?
And so from a financial point of view, this looked like a very good transaction to be a test case. No large blocking position among the minority. A real sense that there was a disconnect between the way the market viewed this company and the way the controller viewed the company from a financial point of view. So that was good because the thought was the minority vote is one that might actually be possible to get. And then a board of directors of the company to be acquired of MFW that offered some, we thought, extremely attractive candidates for a special committee, combining what we thought was demonstrable independence and real expertise, both financial valuation and transactional expertise, so that we thought we could see on the other side of this a special committee that the board of MFW could put together from candidates on that board that would be the kind of committee that the Chancery Court and ultimately the Supreme Court would respect in terms of the special committee review.
And did you think it important, essential to the arguments that you expected to make eventually, that these protections be put in place ab initio from the outset?
We did think it was important, but that was because I understand that there have been cases since in which that issue has been litigated. But we thought, look, this is going to be a test case. So we should try to structure it in a way that makes the test as favorable to the possible outcome of getting business judgment review as we could. So if you think about if you do one or the other of the protections after the fact, then the protections become less powerful. If shareholders know from the outset that their vote is dispositive, they'll come out and vote, and they'll vote their interests. If the special committee knows that if it says no, that's the end of the day, then the special committee will exercise that power in a way that's appropriate. And if both protections were real protections, I thought, and I told our client, that we had a very good chance of getting business judgment review.
And do you have any recollection now as to how long the sort of the negotiation process took between the time of the delivery of the proposal and the announcement of a deal?
Oh yeah, it was quite a while, and again, and this was very frustrating for my client, whose patience is not legendary in some ways, but who was persuaded in this case to be patient. I mean, we said, if you want the special committee to, the special committee's review to be one of the two precipitating factors for business judgment review, you have to let the special committee do what it wants to do, and you have to let the special committee take the time the special committee and its advisors think it needs. And that was not easy for my client, but I think to his everlasting credit, he reined in his desire to get things done as quickly as possible and said, all right, we'll let them work. And that was partly, I think that was made easier by the fact that the people on the special committee were people who clearly knew what they were doing, and they hired advisors who also clearly knew what they were doing.
One of the members of the special committee was resigned or withdrew early in the process?
Yeah, so I don't know the ins and outs of this because I represented McAndrews and Forbes, and the people who were setting up the special committee was Wilkie Farr. I did hear that a clearly independent director from an SEC rule point of view had been either appointed to the special committee or was being considered for the special committee. From the point of view of the controller who was looking for business judgment review, there were competing considerations. I wanted to have very little or nothing to do with anything that was going on the MFW side, but I didn't want there to be any concerns about the independence of the special committee, because that was going to be part of my argument. And I thought that this potential member, or maybe he was a member, I don't recall, while I thought he was clearly independent under SEC rules, he had a very, very long friendship with, or at least say business friendship with Mr. Perlman. And I thought that the better course from our legal perspective was for him not to be on the committee. It's interesting. I think that illustrates how far McAndrews and Forbes and Mr. Perlman wanted to go. There are always rumblings about, oh yeah, there's some insider on the special committee who's influencing the special committee. From our point of view, we wanted to get even the appearance of an insider off the special committee so that the legal issue could be presented as cleanly as possible.
The effort to avoid the appearance of interfering with the special committee's work even extended to asking its investment advisor, Evercore, to prepare business projections with no opportunity for McAndrews and Forbes or Mr. Perlman to see or influence them.
Evercore wanted to develop its own projections, or at least to develop absolutely contemporaneous projections for all of the businesses. So Evercore, through I think Wilkie Farr, as I recall, came to McAndrews and Forbes and said, we want projections made for all of these businesses. And McAndrews and Forbes said, great. And Evercore said, and we want them done. We don't want these done in any unusual way. We want these done in the ordinary course. You're familiar with Delaware law that says projections done in the ordinary course are the most credible for purposes of chancery litigation. And so we said, that's great too. But I was involved in this. I said, that's great too, but you should be aware that the ordinary course in all, well, I don't know about all, but in this particular controller situation is that the projections are done on a business unit basis at MFW, and then they are reviewed at the MFW, at the McAndrews and Forbes level. There are common managers or financial people who deal with both subsidiaries and at the parent level. And I said, we'll do it however you want to do it, but if you want to know what I think what you should want is projections prepared at the business unit level without any involvement from McAndrews and Forbes. And they said, we'll think about that. And they came back and said, yeah, you're right, we want them without involvement from McAndrews and Forbes personnel. And I said, okay, I'm now going to toddle over to my client and explain to them that new projections are being prepared which are not going to be done in the ordinary course because they're not going to be involved in the projections. And I can tell you without revealing attorney-client confidences that was not one of the easiest conversations I've ever had. But again, because this was a test case and because there was a lot of risk involved for the controller here, McAndrews and Forbes was persuaded that they should be willing to deviate from the normal projection process and be entirely hands-off, to the extent that Mr. Perlman himself was not even given the projections until after Evercore had done all of its work and reached its conclusions based on those projections. So no input at all.
What McAndrews and Forbes disclosed to MFW's minority stockholders, on the other hand, benefited from plenty of input in the form of plaintiffs' challenges to those disclosures.
One thing on the injunction proceeding that I thought was very important subsequently, there was what I think was then at least a typical dance in which there are disclosure violations alleged, and we made a supplemental disclosure, and there were no further disclosure violations alleged. That made it very easy for us to argue that the shareholder vote was almost by definition fully informed, because we had made disclosures. The disclosures were, I'm proud of my firm, and I had nothing to do with the disclosures, so I can say it. The disclosures in this case were as clean and clear and crisp as they could have been. But we made some changes that the plaintiffs thought were necessary. And at the end of the day, we were before the court being able to say, look, nobody has said that the shareholders didn't get the appropriate disclosures in order to be able to make an informed decision here. So you should be respectful of the shareholder vote.
Right. Another issue off the table.
Yes.
Finally, the defendants took an unusually forthcoming approach to discovery.
The plaintiffs wanted more discovery. We knew that we wanted to be in a position to get resolution of this on motion. We did not want to go to trial for all of the reasons that defendants never wanted to go to trial in these kinds of cases, because we still had no certainty that the business judgment review would apply, standard review would apply. And we also thought that it was highly likely that the court was going to give the plaintiffs at least some more discovery. So we took a tack that is, I think, unusual in cases like this. We said, tell us what you want. Whatever you want, we'll give you. You want to take every special committee member? Great. You want to take some of the other directors who appointed the special committee members? Great. You want to take Evercore? Great. You want documents? We'll give them to you. And that took time. I mean, it took, I don't remember, but a matter of several months at least for us to deliver the discovery that the plaintiffs said they wanted. And I think and then we moved for summary judgment on the grounds that whatever discovery they want, they've gotten. We will go through the Rule 56 procedural process, and the court should be in a position to decide.
But why did McAndrews and Forbes' counsel think the Delaware courts would abandon Kahn versus Lynch and its holding that inherent coercion in freezeouts always requires an evaluation of entire fairness?
I did not believe that the res judicata argument was a problem for us. I was sure that I could persuade the trial judge that this is an issue that could be teed up, and I was pretty sure that the Supreme Court was going to hear this on the merits. I think the plaintiffs were pretty sure that the res judicata argument was a great argument. There were people in my team who were worried about it. The thing I was most worried about among all the issues we had to face was the Citron problem. You can never entirely eliminate the fear on the part of shareholders that the controller will do something. Also, the author of Citron was on the Supreme Court, and I have enormous respect for the author of Citron, and I was worried that his colleagues would also have enormous respect for the author of Citron, and that this was an argument on which, it's like an infinite whack-a-mole. Okay, no delisting, no cut the dividend, no this, no that, but it's always, there might be something else. So our approach to the argument was to say, I can talk to you about each of the potential forms of retribution that are mentioned in Citron, and I can tell you they won't happen here for the following reasons. And I think that the Chancellor understood that. And then I said, I think that in fairness, anyone who wants to make a structural coercion argument needs to be able to put up an example that is not rebutted by the controller, because otherwise the controller is in an impossible position. And there is nothing to that explicit effect in the opinions, but I think that was the way in which the Chancellor solve the structural coercion problem.
So the Chancellor's opinion was warmly received by defense counsel. But the big uncertainty was how it would be viewed by the Delaware Supreme Court.
So you had your oral argument with the Chancery Court, and Chancellor Strine went back to work and wrote an opinion. How did you feel about the opinion that he wrote, besides having one summary judgment?
Well, I felt ecstatic, but I obviously felt thrilled about the result. That's tempered by the fact that I had always thought our chances were good in the Chancery Court, and that as I told my client, I think our chances are harder to define in the Supreme Court. But I also was very pleased because I thought that the Chancellor's opinion almost couldn't have been better for atmospheric reasons. I have some familiarity with cases in which there is tension between the trial court and the appellate court. And I thought this was a case where there was potential for that kind of attention.
There's been a lot of language and a lot of opinions over the years that suggested that whenever you have a controlling stockholder merger transaction, it's going to be tested by entire fairness. The burden might shift, but it's going to be tested by entire fairness. What did you think that the Supreme Court might do? Even if they said it was dicta, they could easily say, but this is what we think the rule should be.
So the Supreme Court could have done that, and I thought there was a chance that the Supreme Court would do that. This is when I'd been thinking for a long time about the way merger law had developed in Delaware. So it used to be that any shareholder had a veto over a merger, and at some point people saw that this was having at least some damping effect on the ability of people to do transactions. And so there was what I thought was, I'm being very simplistic, but in exchange for a shareholder's veto right, a shareholder got the right to be part of a shareholder vote on transactions like that, requiring a majority, and at the end of the day also got an appraisal right, so that if a majority approved the merger and the shareholder still thought it was a bad idea, at least he could get a judicial appraisal of his shares. So that was one example of, a rebalancing of the power and efficiency of the merger arena. When the entire fairness standard was put into place, it was a recognition that the shareholder vote and the appraisal was perhaps not a complete compensation for the loss of whatever it was that shareholders had before, because there was a specialized kind of transaction in which the shareholder vote was not meaningful, and where the board of directors' review of the transaction might also not be meaningful if the controller was willing to put his thumb on the scales. I thought that the Supreme Court could be persuaded that the reason that the entire fairness review was initially established was not because it was a controller transaction. It was because the protections that had been far earlier implemented for shareholders were being affected by the controller. And so that's why I thought if you could eliminate the effect of the controller on the protections that had already been established, then the court should be willing to say, okay, then we should be back to, first principles, business judgment review of transactions.
And that's exactly what the Delaware Supreme Court did in 2014. 20 years after its decision in Kahn v. Lynch. It held that with special committee and minority stockholder approval, a freezeout could be governed by the business judgment rule, and a complaint could survive a motion to dismiss only if it alleged facts calling into question the integrity of those procedural protections. But the evolution of the law never ends. Even as it announced this major step forward, the Supreme Court's opinion dropped a gratuitous observation in footnote 14, warning that the complaint in the case couldn't have been dismissed because of alleged concerns about valuation. Because such concerns could probably be raised in any freezeout case, doubt remained whether the court's opinion would enable controllers to avoid full-blown discovery or trial.
I remember the footnote very well. I did not anticipate that we would get a footnote with that content, but there was, the Supreme Court argument was a very, very lively argument, and there was considerable skepticism expressed from the bench about the appropriateness of disposing of litigation on transactions like this on motion. And we had a discussion, the two justices who expressed that skepticism and I, about the importance of making sure that there was not too much leverage, artificial leverage, in the hands of plaintiffs because of the nature of the unavailability in all cases of resolution of a case like this on motion. Because of entire fairness. So I thought we might get a 3-2 opinion or a 4-1 opinion. When we got the opinion that we got, which was unanimous, and I saw the footnote, I can only tell you, I'll just say what I thought. What I thought was that was a compromise footnote. I thought it was, I have no information to that effect, but those of us in the room have practiced law for a long time know that that happens from time to time. And I thought that was what it was. I also thought that as a brutal practical matter, it would not have much of an impact. And the reason I thought that was because the composition of the court was changing, and even thinking about three justice panels, but certainly about en banc panels. The next case that came up to the Supreme Court, I thought that a majority of the Supreme Court did not share the view that you couldn't get. The arguments that were made by commentators was this is a case of very limited application because at best it applies only to summary judgment resolutions, and that's not the way people want to do this. And I just didn't think that was the way, when it went back up, it was going to go. Whoever had desired the footnote would either be in the ongoing reconstitution of the court wouldn't be there anymore, or would be a minority vote if he insisted on that as a matter of doctrine rather than as a footnote that was dictum.
Well, your sense has certainly proved to be prescient, because I think that's in fact what's Delaware Supreme Court, I think now has upheld a motion to dismiss at the pleading stage on MFW grounds, as it turns out. So
absolutely, and it was interesting. So almost all of the commentary that suggested that the footnote made this an opinion of extremely limited application came from outside of Delaware. I thought the people in Delaware who thought hard about the actual human beings who would be deciding these questions as they came up again didn't make the mistake that more national general commentators were making.
So Delaware law had come a long way from UOP, and Mr. Perlman of McAndrews and Forbes was satisfied with that progress. even though the approach validated in MFW might not work in all cases.
And I think it's a good way to do transactions. You can't always do them that way, but we at Revlon now, for example, we own about 90% of the stock, and there's 5% that's held by one guy, so you can't have a majority of the minority. So it doesn't always apply that you can do it. Or you may have hostile shareholders that for one reason or another are opposed to it. But if you've got a true shareholder base of size, it's a good way to go, and I'm glad the court liked it.
As Mr. Perlman recognized, of course, no one should conclude from all this that the use of procedures endorsed in MFW immunizes a transaction with a controlling stockholder from attack in court. In fact, the spectacular failure of a special committee of ostensibly disinterested directors led to the biggest judgment, over $2 billion, and the biggest award of attorney's fees, over $300 million, in the history of the Delaware courts. That case arose after Southern Peru Copper, a majority-owned subsidiary of Grupo Mexico, bought Minera Mexico, a Mexican copper mining company 99% owned by Grupo Mexico. The price? About 67 million shares of Southern Peru stock, which were trading on the New York Stock Exchange at about $56 per share, for a total of over $3.7 billion. What did Southern Peru get? A mining company worth, by all accounts, at most about $2.4 billion. That's what caught the attention of Chip Brown, of Prickett, Jones & Elliott, who represented the minority stockholders of Southern Peru.
The core is simple. They're buying something. We know what they're paying. And they weren't even arguing that what they were buying was worth something different from what we said it was. That was another strange aspect of this case. There really never was much of a dispute about the value of Minera Mexico, the Mexican mining operations that were being delivered to Southern Copper. A little bit, but that was never the issue. It was all about whether you devalue the stock. That's what the case turned into. And that's why it struck me as an unbelievably strong case in my eyes.
So the issue was whether the Southern Peru stock issued to Grupo Mexico was worth a lot less than the price suggested by trading on the New York Stock Exchange. That's why the testimony of Harold Handelsman, who chaired Southern Peru's special committee, was so startling.
I would consider their lead witness or main witness to be Mr. Handelsman, who was the chairman of the special committee, or the lead person, or one of the lead people in the special committee. He was asked, the 67 million shares that are being issued to the controlling stockholder to buy these Mexican mining operations, are they worth the market price? I mean, because if it were us, I think we would have said, there's no way we could sell those, that large block of stock, for the market price. He said, but his answer was absolutely, they're worth the market price. And we all, honestly, we all fell out of our chairs because that was that was the key.
That was the $2 billion question.
That was the $2 billion question. It was like, it solved all of our litigation problems, because then, based on that testimony, and I think it comes through it was a focus of the opinions, in connection with these valuation issues, that they always talked about the give and the get.
Right.
And that nailed down what the give was worth. there was no more issue about what the 67 million shares were worth.
And they never did anything to try to rehabilitate that or put another witness on to say differently.
Yeah, that was to me, that was the biggest surprise in the case, because I think if we were doing it on their side, the focus would have been the 67. Instead of doing a discounted cash flow valuation and saying it's worth less than that, you could just say, you have an expert come in and say, if you tried to sell 67 million shares, you would not get $3 billion or whatever, or it ended up being $3.7 billion.
Right.
You would be getting $2 billion. To me, that would have been a better argument. But, it's all hindsight.
Despite the huge disparity between what Southern Peru paid and what it got in return, the deal was approved by a special committee of Southern Peru's board of directors. The committee members were representatives of large Southern Peru stockholders, whose interests were at least superficially totally aligned with the interests of Southern Peru's minority stockholders generally. But discovery revealed that the facade of objectivity crumbled in reality.
Harold Handelsman was an extremely successful lawyer, and really had an impeccable reputation. And he was a very senior lawyer for the Pritzker organization. The Pritzkers are a billionaire family from Chicago that have many business interests, and they were sort of famously involved in Smith versus Van Gorkum. They were the buyers in Smith versus Van Gorkum in that case, and Harold Handelsman had a long career and understood the law, and I don't believe intended to really do anything wrong. But he was at the very end of I believe he was the lead, more or less the lead person on the special committee. And he was trying to get the Pritzkers out. The Pritzker organization had a significant investment in Southern Copper. And so his orders were, we want out. Like, we want get as much money for us and get us out. And he was at the end of his career. He was retiring, and he was just trying to get a deal done. He wasn't trying to steal money or cheat anybody or anything, but it was just a weird set of circumstances that he was at the end of his career. His job was to get his company or his investors out, and so he was reaching, like trying to find a way to get the deal done. It was just a weird situation, I think, where there was a committee, even though they were all highly qualified, presumably or seemingly independent people, for very strange reasons, they all were just desperate to get a deal done.
So, and this is kind of off topic a little bit, but it's always surprised me that, here's Southern Peru, where very competent and reputable members of a special committee advised by world-class advisors really were proved to have gotten it so wrong at trial. But yet, after seeing that, the chancellor went on to pen MFW, which kind of created this new doctrine in Delaware law that allowed controlling stockholders to avoid entire fairness review. Did that surprise you?
A little bit. To me, though, all these cases sort of turn on their facts, because even under a different standard, if you're able to prove that the special committee really didn't function properly based on the particular facts of your case, then then you can win an entire fairness case.
Sure, if you get to discovery to prove your facts.
Yes, the law evolves, but facts always matter. There may never be a $2 billion judgment in a corporate law case again, but Southern Peru teaches an important lesson. Even if the law favors certain procedures, just going through the prescribed motions by rote is a recipe for liability. MFW didn't kill Freezeout litigation, it just changed the issues to be litigated. And courts retain the ability to punish abuse when it occurs.